Acceptance. Acceptance is a clearly stated and unambiguous promise made by one party to another, accepting the terms put forth in an offer. However, the acceptance of an offer has no effect until it is communicated to the offerer. If the offer does not specify the manner for acceptance, any reasonable manner of acceptance will be permitted. Until acceptance of an offer has been delivered, it may be rescinded, even if it was communicated verbally. Although the initial communication of acceptance most commonly takes place by telephone, signatures are required. The acceptance with the buyer's signature can be provided in person, via fax, email, or through the U.S. mail. Note: the basis by which offers are accepted is most often stipulated in the offer. For example, an offer may read, "Acceptance is to be communicated via phone or email." However, the signed acceptance form is to be delivered via fax or hand-delivered within 2 business days of initial reply. There are 4 general acceptance requirements which qualify an acceptance. They include: offers are accepted by the offeree only. Acceptance must be communicated to the offerer in the manner specified in the offer, unless modified or waived by the offerer. Acceptance does not attempt to change the terms listed in the offer. Any attempt to modify or add new terms voids the acceptance. If acceptance is communicated via the postal service, the offer is considered effective the moment that it is dropped into the mail, when it is postmarked. Make sure that you have the correct contract date, especially when counters are used to seal the deal. All the critical dates will be set accordingly, and the terms are agreed upon, and the acceptance was delivered. Circumstances that void offers and acceptance. There are 4 significant negative influences that can disrupt the requirement that consent to the contract is freely given. Contracts become void if a person has lost free consent. 4 factors that void free consent include duress, fraud, undue influence, and mistakes. Duress. Duress is a common law defense. It is the result of threatening someone to do something or forcing someone to do something that they would otherwise not do against their will. Black's Law Dictionary, 6th at Borsukres, defines duress as any unlawful threat or coercion used to induce another to act or not act in a manner they otherwise would not or would. Simply stated, duress is the use of physical force or mental pressure by one party to make the other party agree to a contract. If proven to be a contributing factor to a person's decision process, the contract becomes voidable at the party under duress. Fraud is the intentional, or unintentional, misrepresentation of material facts by one party to influence the decision of another party. 3 types of fraud that can occur in the contract process include actual fraud, constructive fraud, also known as innocent misrepresentation, and silent fraud. Actual fraud. Suppose a seller installs new siding on the exterior wall of one side of the house he is selling to hide fire damage to framing and insulation. He then tells the buyer that the structural integrity of the home is flawless. In this example, the form of fraud is titled actual fraud. It occurs when a person intentionally hides the truth related to material facts to prevent another person from being dissuaded to contract. Material facts are facts which, if known, would have affected the judgment of the other party to contract. In an action for fraud, a material fact must be of sufficient importance, such that a reasonable person would have been likely to have reliance, on the information. A material fact cannot be an opinion, belief, prediction, or speculation, and typically must relate to something in the past or present that can be proved or disproved. Reliance means that the first party would not have chosen to enter into the contract which formed the basis of a fraud action. For example, would not have contracted to purchase a property from the seller. Had the second party not made the representation, promise, or created the false representation. Actual fraud also occurs when a person does not know if a statement related to a material fact is true or not, but claims that they know. For example, A seller's property had experienced water damage due to inadequate water drainage. Later that year, in order to save money, she paid her grandson to move soil from around her house to provide a path away from the house for water to drain in the event of heavy rains in the future. However, she never had this modification inspected to ensure it had been done to code and did not know for certain if the changes would, in fact, prevent the problem in the future. In this circumstance, she does not know if the modification has truly corrected the problem, and if she claims that the problem is fixed, and it turns out that it is not, she may be found liable for damages resulting from actual fraud. Constructive fraud. The second form of fraud is titled constructive fraud. In this form of misrepresentation, a person whose advice is trusted unknowingly provides incorrect information when he intended to provide the truth. For example, a seller innocently indicates that the manufactured home she is selling is rated for colder weather than it is. This form of fraud is also known as innocent misrepresentation. There may be circumstances where a plaintiff is unable to prove a defendant acted with the intent to defraud, but can nonetheless establish a cause of action for innocent misrepresentation. Where fraud has occurred, it can still be difficult to prove, absent a confession by the defendant. In some instances, innocent misrepresentation can provide a good alternative theory of the defendant's liability, such that the defendant's denial of knowledge may support the plaintiff's alternative claim for innocent misrepresentation. In general, opinions are not fraudulent. If John says to a prospective buyer, "This real estate market is going to boom in the next year," and the buyer purchases properties in hopes of capitalizing on the forecasted market, but the market instead declines, the buyer cannot win a suit for fraud. On the other hand, if John says, "This house cost me $500,000, but he paid significantly less for the house, and the buyer purchases the house because he is impressed with its value," John may be found guilty of fraud. Keep in mind, though, that even if John knowingly makes a false representation of fact, he still may not be found guilty of fraud if the buyer failed to find out the truth when it was available to him with a reasonable investigation. Silent fraud. In silent fraud, a person fails to disclose relevant material facts that could affect the judgment of the second party to a transaction. For example, where a seller knows that the plumbing system of the house does not work properly, but does not mention it to the second party, and the first party knows that it is highly probable that the second party would rely upon this information in making the decision to purchase the property. In this case, it is possible that the first party's silence would support a subsequent action for silent fraud. Mere silence is not necessarily fraudulent. That is, the first party is not necessarily under a duty to tell the second party everything he knows. But a seller may be found guilty of fraud if he fails to tell the buyer about a latent defect which would not be found through ordinary inspection. The seller must, of course, know about the defect before he can be responsible for revealing it. The presence of fraud in a contractual proceeding makes the contract voidable by the party upon whom the fraud was perpetrated. As already identified, there are 4 significant negative influences that can disrupt the requirement that consent to contract be freely given. Contracts become void if a person has lost free consent. You've already identified the first 2 of 4 factors that void free consent, including 1. Duress, 2. Fraud, 3. Undue influence, 4. Mistakes,